I'll just mention the adjustments before the opening prayers. Before the introduction, there will be an opening prayer. Very important to do that. After the introduction, will be this is welcome address to replace citation on the late Honorable Justice Idigwe. So what will follow is the this is welcome address. I'm sure you got that. Thank you very much for your understanding. So we begin right away with an opening prayer. Okay, I'm going to call on Professor Eric to give us an opening prayer. Please can we encourage him with a round of applause?
May we rise, please. In the name of the Father, and the Son, and the Holy Spirit. Amen. Dear God, we thank you for the gift of life. We thank you for our successes. I want to commit to this program to your everyone, do for us what we cannot do for ourselves. We pray that this event we have today will be a testimony of your love and kindness to us. These are another blessings we ask to Christ our Lord. In the name of the Father, and the Son, and the Holy Spirit. Amen.
Thank you very much, Professor Eric. Dr. Solomon, and yes, can you come forward, please? Dr. Solomon, and doing this job with me today, my name is Peter Arish. Here's my colleague, Dr. Solomon, and Dr. Solomon, maybe while you maintain a distance, I want to see your face. That is Dr. Solomon, and you're welcome. At this time, we're going to do the introductions of our guests. I'll begin with the very first. Thank you very much. I'll begin with the introduction of Vice Chancellor of the University. Professor Mrs. Lydia Mwesiga Sengano, ably represented by the Deputy Vice Chancellor of Administration, Professor Mrs. Adesua Itoma Samu, who is the chairman. Thank you very much, Ma, for finding time to honor our invitation. Who recognize very distinguished personalities that are here present. And please, as we mentioned their names, we will encourage them with a round of applause as we usher them to the high table during the Vice Chancellor University of Benin. We have our ushers, who will assist them as they come to the high table. Yes. Thank you very much. I'm seeing the lady upstairs. You should join the gentleman there. Yes, thank you. All right, thank you very much. The first honor is okay, thank you very much. Thank you very much. Okay, the first here is the guest lecturer for today's ceremony. The guest lecturer for the 18th Idigwe Memorial Lecture. It is the very distinguished Honorable Justice Benedict Bakwa Kanyi, PhD, FNIALS, FCI Arbitration, and President of the National Industrial Court of Nigeria. My Lord, you're welcome, sir. Welcome, my Lord. Please, another round of applause as my Lord. Thank you very much. The next to come to the high table is the acting chief judge of the district. Okay, the chief judge of the district. The substantive chief judge of the district. I'm sorry, my lord. We are talking of our own Honorable Justice J.I. Archer. My lord, you're welcome. You're welcome, my lord. We're also going to bring to the high table the judge in charge of the Lagos Judicial Division of the National Industrial Court of Nigeria, the Honorable Justice N.N. Esowe. This way, please. Thank you very much, my lord. You're welcome. Please, another round of applause. Thank you, my lord. We're also going to call to the high table the administrative judge in charge of the Abuja Division of the National Industrial Court of Nigeria, the Honorable Justice O.A. Obaseki Osaga. My lord is the son of that, a daughter of the soil. That was what we were told earlier on today. One is the only way from the faculty of law, as clearly attested to by the dean of the faculty of law. Also to join the high table is the administrative judge in charge of Oka Division of the National Industrial Court of Nigeria. He also oversees the Asaba Judicial Division. And that is the Honorable Justice John Tagema, PhD. Lord, you're welcome, sir. You're welcome, my lord. At this time, we're going to bring to the high table the Dean of the Faculty of Law. And that is our own Professor Mrs. Violet I. Okairo. You're welcome, ma'am. Thank you very much. Last week, Friday, we were standing outside with the Dean of the Faculty of Law. It was about 5 p.m. We had closed from work. And then some gentlemen were passing by the Faculty of Law. Yes, please, I see the Dean to be comfortable there. Thank you very much. You're welcome. Back to the story I was telling you. Some gentlemen were passing by the Faculty of Law and then they saw the Dean standing. Well, they did not know she was the Dean. I'm not sure they knew she was the Dean. And then they were making some comments about the beautification of the Faculty of Law. The young man introduced himself as a PhD candidate in the Faculty of Arts, philosophy precisely. And he said he liked what he saw, that the flowers, the way the grasses were well mowed, and then the stones, the painting, he went on and on and on. And I told him, standing right in front of you is the woman who has been doing this. That's the Dean of the Faculty of Law. Thank you very much. You're welcome, ma'am. At this time, we'll move on straight to take the basis welcome address. The Vice Chancellor would have loved to be here herself, but something that is occupying her attention. I'm sure her rep will explain that. At this time, we're going to invite the rostrum, the Deputy Vice Chancellor Administration, who is standing in for the Vice Chancellor of the University of Benin. That is Professor Mrs. Adesua Ijoma Osahon. You're welcome.
Good afternoon, ladies and gentlemen. Our Vice Chancellor, Professor Mrs. Lillian Imotinya Salami, is unavoidably absent because she's currently presiding over the annual conference of vocational and technical education in the Faculty of Education. And she's there as an awardee for today's annual conference. That is the reason why she's not here. And she has asked me to stand in for her, to represent her here. So she sends her apologies and she sends her warm greetings to all the learned colleagues here present. You're all very welcome. The hall is looking so beautiful because of your beautiful dressing. I love the way lawyers dress. So beautiful. So please, you will allow me to stand on the already established protocol. I have Madam Vice Chancellor's address to read out to us. On behalf of the Governing Council and management of the University of Benin, I welcome you all to the 18th edition of the annual Idigbe Memorial Lecture Series. It is worthy of note that this program was instituted by the late human rights activist and nationalist, Chief Gani Fawehinmi, son of blessed memory, to immortalize one of the eminent jurists that this country has produced. It is equally worthy of mention that the institution of this program at the University of Benin, Benin City, by the late firebrand lawyer is eloquent testimony to the pride of place the university enjoys as a center of excellence. Hosting the program in honor of the distinguished jurist, the late Justice Chukwuemeka Idigbe, is therefore a privilege. Significantly, the University of Benin and late Justice Idigbe have a common heritage. The university is the first tertiary educational institution to be established in the old Midwestern region of Nigeria, where the learned jurist served as a chief judge up till 1967. The jurist, a distinguished Midwesterner, eventually got honored with the institution of this annual lecture, and the University of Benin was aptly chosen to host it. Since its establishment, the Faculty of Law, University of Benin, has made giant strides, particularly in turning out well-rounded lawyers who have gone ahead to achieve fame and garner laurels in the larger society. They have done so not just in Nigeria, but also abroad. Many graduates of the university's Faculty of Law have distinguished themselves through dint of hard work to make first-class honors and cut away many awards at the Nigerian Law School. The Univen Law Faculty has turned out eminent men and women in our society who are governors, ministers, top government functionaries, captains of industry, and experts in private legal practice. In all these roles, the alumni law graduates have raised the name of the University of Benin higher and higher, and we remain very proud of them. Only recently, also, the University of Benin produced 6 out of the new senior advocates of Nigeria that were sworn in at the Supreme Court of Nigeria. Also, the current president of the Nigeria Bar Association, Mr. Okunide Akpata, is an alumnus of the faculty. The Faculty of Law of the University of Benin is among the most sought-after law faculties in Nigeria. This is an indication that the university occupies an important position as an attractive center of excellence in all fields of learning, including law. It is our sincere prayer that the objectives behind the institution of this annual lecture series would continue to be achieved, and the task of nurturing leaders of the future who would become properly well-rounded and found worthy in character and learning would be fulfilled. Before I end this brief speech, let me appreciate the team and members of the Faculty of Law who have put this lecture together. No doubt that your continuous innovations and added zests have contributed to attracting this event to be a must attend annually. Distinguished ladies and gentlemen, thank you so very much and enjoy the lecture. Thank you.
Thank you very much. Our amiable Deputy Vice Chancellor, BC of the University, for that insight. Thank you very much. Now, as the course of the program, several distinguished personalities came in. We have to acknowledge them as follows. May I respectfully acknowledge the presence of O.A. Omonoa, Senior Advocate of Nigeria. Let me ask that the Bennett still join the line and still get that. Again, as well, we acknowledge other persons who came in as well on the program. Professor A.G. Badaiti, Senior Advocate of Nigeria, and former dean, Faculty of Law, and Lottery University, Echo. We also want to acknowledge other persons too who are in our midst. Oloruntunmi Williams Daudu, the Chief Registrar of the National Industrial Court of Nigeria. Alhaji Abdul Patel Bello, Director of Finance and Accounts, National Industrial Court of Nigeria. Ibrahim Karaye, Director of Administration, National Industrial Court of Nigeria. Peter Odumaye, Special Advisor to the President of the National Industrial Court, as well as Deputy Chief Registrar of the National Industrial Court of Nigeria. Nuruddin Sapana, Deputy Director in charge of the library, NICN. Olubunmi Alabi, Deputy Director, Admin, NICN. Well, not forgetting Hawaii Yakubu Miss, Assistant Chief Registrar, National Industrial Court of Nigeria, NICN. We also acknowledge the presence of Okunoyi Olufemi, who is among the team of the guest lecturer as well, Albon Cornelius, Modupe Alonge, Dokora Blessing Oluwa, and Edelyn Ikoyi. You are all welcome and recognize their presence. And our advice. Thank you very much, Solomon. At this moment, I would like to acknowledge the presence of very distinguished tourists in our midst. This way. Thank you, my Lord. Thank you, my Lord. My Lord, we're sorry, my Lord. Thank you very much, my Lord. Just an acknowledgement. My Lord, he left other activities to be here. We must acknowledge. Please, ladies and gentlemen, join me as we welcome Honorable Justice Gilbert Jodwin, Justice of the Court of Appeal, Benin Division. My Lord, thank you very much for finding time to honor our invitation and to join us in this event. Thank you very much, my Lord. While the Vice Chancellor's address was on, one of our own walked in quietly, and that is the very distinguished Honorable Justice Obiaru. My Lord, you are welcome. We are waiting for the Edo State High Court. You're welcome, my Lord. Thank you very much for pointing that out. We also have in our midst Honorable Justice Okumbowa. Welcome, my Lord.
There's a further recognition of esteemed guests. We also acknowledge the presence of Honorable Justice A.A. Adewelimo, the admin judge of Benin Division of the National Industrial Court of Nigeria. Also in our midst is Honorable Justice K.D. Damolak, the admin judge of Akure Judicial Division, National Industrial Court of Nigeria. And also, you are most welcome. We also have in our midst Roderick Osewa, Chairman, Senior Staff Association of Nigerian Universities, University of Benin. You are most welcome. As well as Dr. Stephen Obaki Obeki, Director of Alumni Relations, University of Benin, Benin City.
Thank you very much, Dr. Solomon. Yes, we'll be moving on to the next item on our program. Please, we'll do more introductions as our guests arrive and as we get to know you. We are sorry if we omitted you at this point in time. It's not intentional. Madam Vice Chancellor, at this time, we'll be moving on to the citation of the guest lecturer, and that will be done by our the Dean of the Faculty of Law, Professor Mrs. Velvet Iwo. The Dean.
It is my honor and privilege to read the citation of the guest lecturer who has distinguished himself in the field of academics and has provided incentive for most of us to be our best in academics. Before I read the profile again, I would like to again acknowledge Justice Biobel, George Will, just of the Court of Appeal Benin Division, a person I'm meeting for the very first time, but who have been in contact with me and offering me useful advice on how to move the Faculty of Law forward. Please, gentlemen, assist me. And I go on to read the profile of Honorable Justice Benedict Kanye. Honorable Justice Benedict Kanye was appointed the judge of the National Industrial Court in 2000 for an educational institutions. He was also the National Minor Committee of Social Responsibility set up by the Standards Organization of Nigeria, SON, under the auspices of the Federal Ministry of Industries. Professor Khalid is member of several associations, including the Nigerian Bar Association, Fellow Chartered Institute of Taxation of Nigeria, Fellow Nigerian Institute of Advanced Legal Service, Health, and also a member of the Nigerian Society of International Law. He is a contributing editor to several academic law journals. He is the president of the National Industrial Court of Nigeria. That is the specialist course on employment, industrial relations, and other matters. Having been appointed into that position since 2019. The impact of the court under the leadership of Honorable Justice Khalid has been very profound in the lives of all workers and employers, giving to primacy on employment and trade union matters throughout the country to the exclusion of other courts. As a thoroughbred academic, Justice Khalid has brought his training as such to bear in the workings of the courts, delivering groundbreaking judgments that have positively impacted in the labor law jurisprudence of the court. Yes, Justice Khalid was not initially known as a guru in labor matters. He originally established his expertise in consumer protection law and remains one of the leading lights in the area of law. Indeed, he has brought his expertise in the field of law to the workings of the court by making the court very friendly to consumers of its services, especially litigants in terms of service delivery, while emphasizing technicality in favor of substantial justice. Justice Khalid is a much sought after person in the lecturer circuit. He has presented several papers in his area of expertise across several universities throughout the country and several professional bodies and associations, including the Nigerian Bar Association, the foremost professional body of lawyers. Given the esoteric nature of law, it is expected that my Lord will deconstruct the myth surrounding the court concerning the clash of contending rights between a staff who approaches the court for relief over his employment that has been terminated, and the employer who is at a loss as to why the court should question his power to discipline staff. Note that the lecture will be exposure. Madam Vice Chancellor, ably represented by the Deputy Vice Chancellor, Academic Professor Adesua Sahor. Standing before you is this judicial grandeur. Honorable Justice Benedict Ayim, PhD, President, National Industrial. Thank you, Gossip Amanoa SAN. Your clap gave me a lot of courage to continue.
The Dean Faculty of Law, thank you very much. I think my Lord, the President of the National Industrial Court of Nigeria deserves another round of applause. Thank you, my Lord is more of a researcher than he has written so much. Thank you very much, my Lord. Shortly, we'll be going into the main lecture. I will just do this, take this. We have one of our own, a rare gem and a distinguished academic. She is the head of, she's the head of the tax tribunal, South. What I thought, yes, it's quite different. She's the head of the tax tribunal for South. Yes, yeah, no, I know that very well. And that is the very distinguished Professor Mrs. Odiase and Legendary. Thank you very much. Shortly we'll be calling my Lord up to deliver his lecture. I can assure you that you are going to learn a lot from my Lord. We had an interactive session at the Faculty of Law. My Lord's explanations of some key principles of law were quite enlightening. And my Lord is going to be speaking to us this afternoon. We're going to be calling him up to deliver his lecture. Please, with a round of applause, to the most strong to deliver the 18th Antigua Memorial Lecture. This is a round of applause. It's not a round of applause. Welcome, Lord.
Chancellor, Judge Will, the Lord, the Chief Judge of Edo, who incidentally was my head of chambers when I served here. My colleagues are with me, some of them. There are Milots from State High Court here. I can see S.A. Modowa. I can see Professor Bagaiti, my contemporary. Never had the opportunity to congratulate you on assuming the position of silk. Let me do that publicly. Please just stand up so that they can see you. Why I say if you can get the paper, look at the intro. Is one of those who read drafts and commented. But I said that all problems with the paper, I take responsibility. It has nothing to do with it. You flew in from Lagos just for this. Because we are praying and get silk. Thank you for having me. To all the professors from the law faculty, staff, interacted earlier in the day, I can see some students of the faculty here. The Vice Chancellor has already commented to address it. Let me add to our words.
You are impeccably dressed. Well done. I was only part one trading law. So it's a huge honor for me that I'm already sorry that I am fit to do this lecture. I thank you for that honor, and I pray that I will not disappoint. I served in this state 86 to 87, but I never came to the law faculty until today. Why, I really don't know. And I have friends who actually graduated from here. But once again, better late than never. I am to talk on the impact of the National Industrial Board on employment rights. I understand I have an hour or less, so we'll see how we can rush it. What I'm asked to talk on, my understanding of it, is whether the NIC upholds employment rights or, and if it does, the extent it does so. But the topic assumes that the NIC and alongside other institutions promotes industrial harmony, but questions the extent. The topic also assumes that there is a clash of interest in employment rights. I'm 2 years in the Health Affairs at the court, so I want to believe the topic also assumes I will do some kind of stock taking. Where we came from as a court, where we are going as a court. So in determining the role of the NIC, the key question calling for determination is the impact of the decisions of the court on employment rights and how those decisions have resolved the clash of interest in employment rights, if any, and promoted industrial harmony in the process. I then took a little excursion into the historical antecedents of the court, just to show a point. And what is that point? That the jurisdictional trajectory of the court rose over time. In 1976, when it was set up, the jurisdiction was restricted to only trade disputes. 1992, it was expanded to include intra and inter-union disputes. 2006, in virtue of the 2006 National Industrial Board Act, was expanded to include labor, industrial relations, and trade union matters. And by the time of the third iteration in 2011, National Industrial Board was given jurisdiction over all employment, labor, industrial relations, and matters incidental thereto. Now, a look at this narrated story shows a deliberate progression in the jurisdictional matters granted to the court over the years, from mere trade disputes to all labor and employment matters. So I can restate as follows. From mere collective labor disputes to all labor and employment disputes, including individual employment disputes. We need to have this in mind just so that we can appreciate the role of the court and indeed its impact on employment rights. Now, before 14th June 2006, when the NIC Act came into effect, the jurisdiction of the court was restricted to only collective labor disputes. But with the coming into effect of the NIC Act, individual labor disputes which could not be determined through the processes of Part 1 of the TDA were allowed to be determined by the court. The landmark judgment decision of Godwin Osamobi versus Gulf Agency and Shipping Nigeria Limited, which was delivered exactly on the first year anniversary of the Act itself. Now, I mentioned earlier that the topic assumes that NIC has a role and are required to do some kind of stock taking. The statistics in the paper are as at last year, because when I wrote this paper last year, it was actually meant for presentation last year, but corona's hindered it, as I mentioned earlier. So, as at 13th March 2020, globally we had 6,596 cases, with the most coming from Lagos division, followed by Abuja, then Port Harcourt, and then downwards in that manner. The Constitution permits us to establish an industrial and an alternative dispute resolution center. So I made a statement on that and noted that lawyers, out of these 6,000 plus cases, only about 66 were actually referred to media. What it tries to tell us is that lawyers are not comfortable using that system. Of course, I noted that we are looking into that issue. One of the issues asked even in the interactive session I had with the staff of the law faculty, lecturers and staff of the law faculty, was that NICs and employee courts are not necessarily a court for all. So, because of that accusation, sorry for using that word, I had to get the details of the kind of judgments given, who won, who lost. You would find the statistics in paragraph 11. Yes, lawyers, employees tend to have most, because they are the ones who in the main come to court as claimants. So they have a higher percentage of the winnings. But still, that does not mean that the employers have lost out. So I made the point that yes, conceptually labor law came about simply because of the unequal bargaining power between workers and employers. And because of that, the law had to assume a kind of paternalism in the interest of workers. So, in admitting a good deal of paternalism on the part of the law itself in protecting the rights of workers, I note the point that in deserving cases, in fact, I itemize examples in the paper where in certain occasions, even where the employer did not appear in court, even where he was not represented in court. The claimant, the employee who came to court, lost. And I am making that point advisedly and seriously to show that yes, the purpose of labor law may be worker friendly, may have evolved because of workers, but that does not mean we have forgotten the interest of employers, because in deserving cases, employers too have won. In fact, you would find the basic structure of the paper, even when the paper asked me to discuss the clash of interest in employee rights, I also took time towards the end of the paper to discuss what I call employer rights or interests. So I acknowledge that a good deal of paternalism is in the law, but even at that, employers have actually won in deserving cases. Now, I also showed example how paternalistic the law is, and this is evident in terms of some of the rules that we apply as a matter of course. For instance, we have the rule which grants the employee an absolute right to leave an employment even when he is being investigated for an infraction. And any inhibition by the employer is held to be forced or slave labor. I'm going to make a comment on this much later. We also have the rule that labor laws, when ambiguous, are interpreted to the benefit of the employee. In other words, ambiguity is resolved in favor of the employee. We also have a rule which I said is culled from the law of arithmetical approximation, where anything from half but less than 1 is approximated to the next whole number. I told the teaching staff of the faculty how this works. Sometimes you have examples of conditions of service indicating that you are not due for gratuity until you are 10 years. Employer waits until you are 9 years and maybe 5 months or 9 months or whatever, and tells you your services are no longer needed, just so that he will not pay you gratuity. Matters like that coming before us, we say no. You use the form So in today's world, labor law itself, like I pointed out, is in crisis. I've had course previously to allude this to write-ups, something that Professor Chioma Akomo, who just retired, also acknowledged. So the talk today is about the identity crisis of labor law. And what is that crisis? The extravagant individualization of the common law. There is a debate as to the choice between individuation of labor rights, which is employment law, or their collectivization, which is labor law. The crisis of labor law is described by an author who couched the challenges of labor law in terms of conceptions of the notion of worker, the melting boundary between employment and unemployment with job insecurity, elevated into a market asset, the threat posed by globalization in undercutting basic social yield rights, yielding to the necessity to counterbalance the hegemony of free trade ideology, the growing inability of trade unions to cater for those out of work or even marginal workers. All of this points to the importance of ensuring that the labor law is facilitative of collective bargaining and social dialogue, rather than simply providing for individual rights. The thing about this crisis of labor law is that it has exacerbated further and increased workplace disputes. Aside from globalization, there's also the problem of the gig economy and the interposition of artificial intelligence in the workplace. All of these are complicated issues. At a point, I have course to address in greater details issues attending robots and artificial intelligence in the workplace. Even the International Bar Association has conducted a study in this regard. Because part of the problem is we are having robots beginning to replace employees at the workplace. And the question now is, for us in labor law, who is the employee? There is this assumption always, labor law is about the binary relationship between employees and employers. And we have this idea, the employee is usually a human being. The employer may not be a human being. So where the employee is replaced by robots for purposes of labor law and its protective stance, is a robot an employee? Of course, that question has not come before us, but I'm bringing it up to show that elsewhere, the gig economy and the influence of artificial intelligence in the workplace is stretching further what notions we have about who an employee is, who an employer is, and what an employment relationship is. Of course, for purposes of liability, the robot causes an injury, you can hold the employer liable. But again, questions arise how you treat that, particularly knowing that most of our laws were involved in circumstances that dealt with human relationships, not robots. So the flexibility of the workplace as enhanced by the gig economy has not gone unnoticed by commentators. In fact, there's an author, Jack Esperetti, who points out in very scary terms the idea of a new form of work that would dissect the world of work. To him, this new form of work is the slave army of robots, a slave army of bosses. It works this way. You are your own boss. Take, for instance, an Uber driver. He is made to think that he is his own boss. And in this new globalized, de-unionized world, because the idea now is, if you are your own boss, the question is whether you are an employee for purposes of unionization. Can you join a union? You are part of a giant amorphous freelance class known as the precariat. In the name of flexibility, you are precarious. living a paradox boss of your own destiny, which living is from hand to mouth. You are the boss and a slave simultaneously. The middle class professional has dignity at work, but as wages go down, so too does that sense of self-worth. And as this army of slave bosses grows into an ocean of cheap available labor, so comes the biggest opportunity to transform work. Now, this new system is a very clever one. It depends on young temporary workers who will move on. The new system is who will move on, and so no one hangs around long enough to complain or cause trouble. There is never going to be an employee problem, as there is always someone new to do the job. This author noted, however, that the low-paid workers are now fighting back. Just of recent in England, in February of this year, the UK Supreme Court held that Uber drivers are workers for purposes of labor law in England. Of course, I think I read of this, I don't know whether it's France or Australia, they too told the lines of the UK Supreme Court. Because Uber had argued that, look, these are not workers, they are independent contractors. But the UK Supreme Court said, no, the degree of control you exert on these drivers is sufficient to make them workers, since they really cannot do certain things except they get clearance from you. Now, this author then concludes that all of this gives rise to two competing visions of a new capitalism: to be a slave or a slave boss. So that the sharing or gig economy with its planet of slave bosses is the largest transformation in our working lives since the Industrial Revolution. Now, instead of sharing music, we share employees. Optimists for this sharing economy refer to this free market equality as dot communism, which incidentally undermines anyone setting themselves up as an authoritarian boss, because it empowers the individual to choose where and how to work. Freelance or hyper-flexible so-called contingent work is thus growing at an exponential rate. In fact, the word contingent is itself interesting. It means that you are employed contingent on there being anything for you to do. Now, this is the scenario we found ourselves last year when COVID-19 struck. Of course, I am not saying much on that because you never can tell the kind of cases around there that would come. So I simply note the impact of COVID guidelines that ILO gave, and the fact that they press more on consultation before employers make decisions. Later on, you are going to find out one of the rights of employees is the right to be consulted. Now, I am not unmindful of the fact that conflict is inevitable in the world of work. Even when we talk of industrial harm, the workplace, the promotion of which the NICF must and does play a role. This does not imply the absence of conflict. For as one of our former judges said, conflict in the dynamic relationship between management and labor is inevitable, as the voice of dissent is the hallmark of industrial democracy. In fact, as a matter of fact, the legitimate expectations of the employer and labor are constantly in conflict. Workers want more wages, and employer wants to reduce wages as much as possible. Workers want job or employment security. The employer wants flexibility. So that relationship and the expectations of each group in the relationship is one that is constantly at war with each other. So when we talk about resolving clash of interest in employment rights, which is found in the topic I am talking on, it is nothing but the interplay of these competing interests. How the NICN has thus grappled with this competing interest will unfold as we continue the discussion. So, this is the context that i.e. having to balance this competing interest that NICN must act and perform its constitutional role of adjudication and settling labor/employment disputes, and by extension, setting the standards of conduct in labor and employment relations. Adjudication, like I note in the paper, is but one of many dispute resolving parts. Now, there are several means of resolving labor disputes. I note collective bargaining, industrial actions. Many are surprised that when we talk about dispute resolving mechanisms, we put strike as one of it. But the truth of the matter is that a strike is a dispute resolver. Industrial action, mediation, conciliation, arbitration, and adjudication. All of these come within the concept of social dialogue, espoused by the ILO. And to the ILO, social dialogue remains the key to managing conflicts in the workplace. And the disputes calling for resolution at the NICN often end up determining rights, privileges, and obligations of the disputing parties. But the role of the NICN, especially as a specialized court, is not solely for the enforcement of their contractual rights. We almost make the point that our main role is finding what is just in the world of work. As an industrial court, dealing with only labor and employment matters, and matters incidental thereto. The NICN is industrially informed and so understands workplace issues. We are not alone in this. In fact, after I wrote this paper late last year, Honorable Justice Otapo of the Court of Appeal delivered a judgment that sets the tone of how the modern day National Industrial Court ought to be. I didn't have opportunity to reflect that particular judgment here, but it's something that is worth looking into. But some of my colleagues keep telling me each time they're writing judgments, they must refer to Sahara. They must refer to Sahara. That's the judgment of Justice Otapo. At the NICN, we are not only realistic and worldly wise, we do take a sensible and robust view of the competing interests that call for adjudication. And the competing interests, as between employers and employees, have given rise to labor/employment rights. What then are these respective rights? How has the NICN treated and applied them in the cases that come before it? And in applying these rights, has that promoted industrial harmony? As I seek answers to these questions, I must make the point that the rights talked of here can be considered from the perspective of rights of employees and rights of employers. So I go into rights of employees. Before looking at the respective rights, I must make two preliminary points. One, Section 17 of the Constitution provides that in furtherance of social order, the ideals of equality of rights, obligations and opportunities before the law, the sanctity and dignity of the human person, humane governmental actions as well as just and humane conditions of work, zero tolerance of human exploitation, equal pay for equal work, and the health, safety, and welfare of all persons in employment are all fundamental objectives and directive principles of state policy. Now, I need to make a point. The current constitutional dispensation allows the National Industrial Code to apply international best practice. Most of this, later on, when I talk about rights, I'm going to divide them into political, civil and political rights, and economic and social right, what is called the ECOSOC rights. The ECOSOC rights, for said to be not justiciable because the majority of them come within the context of the fundamental objective and directive principles of state. But a lot of people misunderstand that because NIC now has authority to apply international standards, conventions, treaties, protocols ratified by Nigeria. Most of the international instruments Nigeria has ratified actually encompass this ECOSOC rights. So if you can build up a case within that structure, you can validly get a remedy in respect of them at the NIC. 2, in labor relations, labor rights inure at 3 levels. We have pre-employment rights. Sometimes we think that when you apply for a job, the fact of application for a job has not yet given you a right. It's an erroneous thinking. If you apply for a job and the employer is, sorry to use the word, stupid enough to tell you, I won't take you because you come from this part of the country, you can come to us on discrimination, on grounds of discrimination, that you were not properly considered, and that's why you lost the job. We may not give you the job, but you get damages because employment rights inure at pre-employment level. That's why applicants who have a certain rights, an applicant has some rights, which if infringed, can give him the locus to come to court. Secondly, rights also inure while you are in employment. And thirdly, rights inure after an employment. I'll give you 2 examples. The right to have a work reference given to you. Pension rights. These are post-employment rights. So, employee rights inure at 3 levels: pre-employment, while in employment, and post-employment. So, in the world of work, there are principally 2 employee rights: civil and political rights on the one hand, and economic and social, what is called ECOSOC rights on the other. Regarding civil and political rights, there are 3 key ones: freedom of association, right against discrimination, and the right not to be enforced or compulsory labor. But each of them has its own brand of issues. Let me see whether I can run through some of these issues. When we take freedom of association, for instance, it also includes the negative right of freedom not to associate. Sometimes we have difficulty. Take, for instance, the current context of unionization is that junior staff are deemed to be members of their respective trade unions, but they have the right to opt out. Senior staff are not deemed to be members. They must individually and in writing opt in. We've had problems with lawyers coming to us. The law says everybody is free. How can you say junior staff are deemed to be members and so on? They forget. I'm sure the Lord will bear me witness here. In law and in logic, the converse of a proposition commands the same respect as the proposition itself. I'm sure we are familiar with that. For students who are, I don't know how many of you are doing law of negligence. What is negligence? Negligence is a fault-based liability, right? You are held liable if you are at fault. It means if you are not at fault, you cannot be held liable. So the converse of a proposition commands the same respect as the proposition itself. So when you have the freedom to associate, it comes with the negative right of freedom to disassociate. But nowhere, when you consider the question of the right to freedom of association, the major problem that comes with it is the right to strike. Why is that a problem? Because the Constitution does not specifically mention the word right to strike. I see my colleagues say we interpreted the Constitution and we did not see this word. Consequently, that thing is unconstitutional. For me, it's too narrow an approach to constitutional interpretation. Now, when you deal with the right to strike, two perspectives stand. First, industrial action is seen by some people as an individual, as a fundamental human right. Secondly, we sometimes see industrial action as at least a very important labor right. I am later going to talk about the constitutionalization of labor rights. In other words, I'm going to ask the question, would a worker prefer that his rights as a worker are made constitutional? Or would he prefer that they are simply made as labor rights? I will come to that question in due course. Now, the thinking that the right to strike is a fundamental human right has three key implications. One, if you look at it as a fundamental human right, then you must come to the conclusion that it is a right vested on the individual. Which means in a workplace like the University of Benin now, an individual law lecturer can decide to wake up one morning and say he's not happy with the policies of the university and carry a placard and say he's on strike. The second implication is that it is a primary right rather than a secondary right. And as such, is released from its dependence on collective agreement. There are jurisdictions that insist the right to strike must stem from a collective bargaining. In other words, collective bargaining must start, fail, before you can go on the right to strike. In jurisdictions like that, the right to strike is treated not as a primary right, but as a secondary right. Thirdly, the third implication relates to the obligation of the state, which is to ensure that there are no legal impediments, such as branding the strike as breach of contract or as a ground for permanent replacement when it is exercised. Now, the human rights dimension of the right to strike yields to an additional inquiry whether the right exists to promote other rights. Can workers use the right, for instance, to protect the freedom of expression? Can they use the right to strike to insist on certain forms of dignified working conditions? The argument here is that the right to strike may be exercised to protect or promote other human rights, such as freedom of conscience, freedom of expression, freedom of association. So the human rights which the strike is designed to protect may be the human rights of all parties, e.g., a strike to secure the reinstatement of a sacked employee. In one of the cases that came before us, the argument was even made by the employer that nowhere in the letter of termination was it stated that the claimant was terminated because of his union activities. What the NICN held was that this argument was self-recognizing and laughable, as there is no employer who would ever write that he's terminating an employee's employment due to trade union activities. So there is difficulty in choosing an appropriate approach. And this explains why most legal systems, including Nigeria, opt for some kind of middle position in which strikes are lawful only if certain conditions are met. This way, the right to strike is supposedly protected while minimizing the disruptions to the economy. Middle positions such as this are, however, difficult to operate in practice. The exercises only if it is in contemplation of a trade dispute came before me. In fact, the last I think it was 2016, around that time, there was an increase in the price of fuel. And NLC went on strike, government sued. The argument was that the increase in the price of petrol is not a trade dispute. And because it is not a trade dispute, NLC cannot go on strike on it. Matter came before me, and given the jurisdiction we have to apply international best practice, I have to look at how ILO's jurisprudence on the right to strike is couched. What ILO said is that in appropriate circumstances where the welfare of the generality of workers is affected, there can be a right to strike for political or economic reasons. And applying that particular principle, I held that in the given situation of the increase in the price of petroleum product, the workers were perfectly upright to have gone on strike. The right to strike is linked to collective bargaining. Two implications may arise as to the scope. One, a legitimate strike would have to be related to the issues which are the subject of the collective agreement. If you say the right to strike is second, stemming from a collective agreement, then it means the issues for which the strike is done must be issues related to the collective bargaining. Two, if the right to strike is linked to collective bargaining, it should be regarded as a collective rather than an individual right. In Nigeria, we generally hold that the right to strike is a trade union right, which inures only to registered trade unions. It means if you are not a registered trade union, you cannot go on strike. Secondly, it also means that because it inures to a trade union, an individual cannot go on strike. But generally, you will find that the right to strike is limited. The reasons given for limiting the right to strike, I give three in the paper. One, to prevent disorder or crime, as where picketing and other demonstrations organized during a strike may involve the commission of crimes. Two, there are certain groups that are generally barred from industrial action. For instance, those engaged in essential services and security agencies. And three, there is a need to protect the rights and freedom of others. For example, employers, other workers, consumers, and the public at large. Even within an organization, not all workers may subscribe to a particular strike. So, labor jurisprudence dictates that you must respect the rights of those people. Once they indicate they are not interested in the strike, you must allow them the leverage not to be part of it. So, trade unionism, the vehicle through which freedom of association finds expression in the workplace, presents its unique issues for especially employers. And employers have grappled with it differently. To start with, it is illegal for an employer to prevent employees from joining the relevant and requisite trade unions and other labor associations or interfering with unionism in the workplace in any manner. In fact, if you run through the cases, particularly court of appeal cases, you will find out right strictly entrenched, no interference of any kind. And for the kind of cases that have come before us at NIC, we have, for instance, involved rules that say there are certain kinds of disputes that an employer cannot even be a claimant. For instance, the question of who should rightly unionize sets of workers in an organization. An employer cannot be a claimant because we interpret that as interference. The only person that can come with that kind of question is either a rival union or members of the union itself, who may be querying their membership. Employers often think that they can has convened this group. So sometimes what we see is that they engineer a group of workers to sue the rival union and make the employer the second defendant. I don't know whether you get the point. The employer ordinarily cannot be a claimant. So he engineers a group of workers, go to court, sue the union, then make us the second defendant. When we come to court, when we are making our submission, we will say we have no problem with what you said. I've had about 2 or 3 of that, and I have to, in the judgment, speak harshly about that kind of strategy. In fact, in one case, the argument was very funny. This is what the claimant said. He said, as an employee, while in the defendant's service, the defendant company gave him consent to join a trade union. Also, that the defendant was a party and had been privy to his membership of the association, while he, the claimant, was in the employment of the defendant, as well as being a bona fide member of the particular trade union in question. We made it very clear that the argument only betrayed the claimant's lack of understanding of the very import of trade unionism in the workplace, and we held that that fact alone was evidence of interference on the part of the employer. There is an ancillary issue which relates to the employer's treatment of a collective bargaining in the workplace as it relates to employees. Sometimes you find I think it's a call of appeal position, CCB Nigeria Limited, I suppose, where the call of appeal held that an employer who paid benefits to an employee under a collective agreement cannot come around and say the collective agreement is binding upon it. But there are a number of issues. Remember, I started off by saying junior staff are deemed to be members of the trade union. So, for junior staff, there's no problem because they are deemed to be members of the trade union. So, the collective agreement would apply to them. There's no problem with that. The problem is usually with senior staff because they ought to opt in. When you come to us as a senior staff and you lay a claim, giving your claim on a collective agreement, the first question we ask is, are you a member? And proof of membership is not a function of pleadings, because membership cannot be conferred by a third party. An employer cannot confer on you membership. We've seen cases where the employer said, I am a member of this, the employee said, I'm a member of this union. In the pleadings, and the employer said, I admit paragraph X. Then the counsel to the employee comes to us and says, because of that admission, he is a member of this union. I will say, no, membership is not a function of pleadings. First is a question of law, and you must prove it by documentary evidence. If you are a member of a union, they must give you an ID card. If you are a member of a union, you must pay union dues. So if you bring the pay slip showing deductions of union dues, we will agree you are a member. But you cannot by pleadings tell us you are a member. Secondly, the employer cannot confer membership of the union to you. Thirdly, as a senior staff, you individually and in right must join. And I've seen quite a number of organizations fall trap on this. Senior staff associations will just bulldoze their way. The employer falters and caves in. Instead of asking, we don't have any problem giving you checkup, but we need individual letters from each staff indicating they are joining you as a union. In fact, because the law talks about individual and in writing, we say it cannot be collective. You cannot, for instance, say we, the undersigned, hereby join this union and all of you sign. No, it has to be individual. Freedom of association in the workplace has its flip sides. I tell the story of a case before me. Somehow they settled, but something rattled me. One of the documents that was put in was an application by the union. Meanwhile, the case before me was a tussle between two unions who can unionize the workers. Now, one of the documents that was put in was a document by one of the unions to the company asking for a loan of about 400,000 and saying that the repayment of the loan should be taken from the check-off dues. I don't know whether you get the point. A trade union having a case with another trade union. One of the documents it brought forward is to say we want civil wrote asking for a loan and that the money should be taken from the check-off dues. Now, I ask some questions. Is it legal to pay check-off dues in advance? Is it legal to pay check-off dues in advance? Why did I ask this question? Salary is paid in arrears. It's at the end of the month we all collect salary. So if you say, give me a loan of this and take it from check-off dues, it means you are mortgaging it against future. What you have done is you have collected check-off dues in advance. Since salary by conception is almost always paid in arrears, should check-off dues not also be deducted and remitted only when salary is paid? When a trade union borrows check-off dues in advance from an employer, will that trade union have the moral courage to challenge the employer if the need arises? How did the trade union manage these accounts in the first place to get to that sorry pass that has necessitated it asking for a loan from an employer? In this regard, where is the registrar of trade union regarding his oversight responsibilities over the accounts of the trade union? If the employer had insisted on some sort of interest over the check-off dues sought for in advance, would that be legal? After all, as we say in good, there are no free lunches. There's even a very more profound question. The issue that was before me was which of the two unions should unionize. Now, let's assume this union that collected the money, the loan, we held that it is not the union to unionize. How would they repay the loan? Which check-off dues will it get to return that loan? Because the loan was hinged on the payment of check-off dues. So, sometimes what we see in the workplace, that's why I said trade unionism has its own flip sides. The last point on the issue of unionism, we made the point that a trade union has not been bequeathed the right or appointed to police the world of work. We've seen cases before us where a trade union will come and say, it is suing a particular employer because it did not do certain things in the place of work. And we have held that if you are not set up to be a policeman of the world of work or labor practices, the Ministry of Labor is there. Now, the second civil and political right in terms of the right of a worker is the freedom not to be discriminated against. Before looking at this right more closely, I must say that it typifies a wider policy dialogue which is constitutionalization of labor rights a better way of protecting the interests of employees? I said I ought to have asked this question earlier, but it is better treated when dealing with the right of discrimination. Now, why do I say so? There was a federal high court decision where the suit was in relation to somebody claiming to have been discriminated on grounds of being HIV positive. And the federal high court held that under the right against discrimination in the Constitution, HIV is not one of the grounds. Now, if HIV is not one of the grounds, it means that discrimination on the basis of HIV cannot be a constitutional right. We must now go back to labor law. Now, when you go back to labor law, the word discrimination is not used in any labor act except the Trade Unions Act, and it is used only in terms of membership of a trade union. In other words, you cannot be discriminated upon and denied membership of a trade union. It has nothing to do with your employer treating you shabbily because you are HIV positive. So, I now ask the point, if we constitutionalize labor rights, then it means that each labor right that does not qualify under the Constitution cannot be litigated upon. And that's why I asked the question, would an employer best want to have his rights constitutionalized or simply made a labor right? I remember the Lord's colleague, Justice Nimbar, one time we had a discussion. How do you people treat this thing about discrimination in the workplace? I said, these are some things you are not going to find clear. But the starting point is first, we have authority to apply international best practice. Secondly, you must be ready to draw analogy from the other forms of rights. Take, for instance, the right against the right of human dignity. How you treat a worker in the place of work is also an important consideration and inures to the right of human dignity. In fact, there are court of appeal decisions that are very clear and insist that an employer, for instance, cannot impose several conditions on employees. So, when you look at rights related to forced labor, rights related to discrimination, rights related to human dignity, a global reading of some of this right gives you the jurisprudential footing to insist on certain conduct on the part of the employer, even at the workplace. In fact, there was a case that came before me, and partly the argument of counsel was that the grounds upon which discrimination was being pursued ought not to be because they were not listed in section 42 of the Constitution. And I looked at section 42 more closely, and I said, the way it is couched, it did not couch it in a manner that suggests that those grounds are exhaustive. And because it was not couched in that manner, I held that section 42 admits of other forms of discrimination being argued under it, and so I rejected the argument of counsel. Now, the third civil and political right is the right against forced or compulsory labor. And here, what you have in mind is section 34(1) of the Constitution, section 73(1) of the Labor Act, and of course, the ILO Convention on Forced Labor, which Nigeria ratified. And I use one point to illustrate how this works. There is a court of appeal decision which held that, and in fact, most establishments do have that. Even at NJs, the disciplinary provisions relating to judges also has a provision that says if you are being investigated for purposes of discipline, you cannot resign. And for us at NIC, we say that it is forced labor. There's a Court of Appeal decision actually that said a suspended staff who is investigated for an infraction cannot resign. But I looked through the judgment and I did not see section 34 of the Constitution considered. I did not see section 73 of the Labour Act considered. And of course, they didn't consider the ILO Convention on Forced Labor. Now, Nigeria has ratified the ILO Convention on Forced Labor. But my colleague, she also did a decision where she followed the Court of Appeal decision in holding that you cannot resign if you are investigated. But again, Justice Obasanjo's attention was not drawn to section 34 of the Constitution. The case was not argued on the basis of section 33 of 73 of the Labour Act, neither was the Convention of Forced Labor considered. Now, if you read the ILO literature on forced labor, it tells you that any inhibition to an employee is tantamount to forced labor. I remember vividly when I was a member of the technical committee reviewing labor laws. The issue was whether we should incorporate matters in Convention 158. Convention 158 is the one that deals with termination. And the key provision in that 158 is that an employer cannot terminate without a reason. The representatives of employers said, if we bring that, there must be a reciprocal provision that insists that an employee who is leaving must give a reason. But if you read ILO prescription on this, ILO is very specific. The right of an employee to leave must be an unhindered right. So the fact that an employer must give a reason before he sacks has no corresponding obligation on the part of the employee to give a reason before he leaves. That's ILO. So the matter that came before me, I reviewed all of this and held that the right to leave is unfettered. And in fact, in the paper, I referred to section 306 of the Constitution, which relates to constitutional office holders. If you read that particular provision, you are going to find that it says any constitutional office holder can leave, can resign, and the resignation takes effect as soon as the letter of resignation is given to a person who has authority to receive that letter. I'm sure you all remember the scenario involving our former Chief Justice of Nigeria, Justice Onoke. There was a time he began to accept his resignation or not to accept it. I remember going the attention of my predecessor, who was a member of NJC at that time, section 306, and telling him, look, you people don't have a choice here. The moment that letter of resignation had been received, effectively does no longer resign, and there's nothing you people can do. That spirit behind section 308 is the unfettered right an employee has to leave. People have asked questions. But what about the investigation? And I said, it's up to the man. Remember, I said there's a right to work reference. You left the job tomorrow when you leave. Somebody is going to write to the employer. Oh, tell us about this man. If the employer, for instance, writes that, oh, he left at a point we were investigating him and we could not conclude. What does that say? So it's in your own interest as an employee to make sure you're clear before you leave. If you don't, it's a hand, something that is hanging on you. And for life, you will have to be explaining why you didn't wait for you to be clear, and so on. And now go to ECOSOC rights. So let me see whether I can rush. I made the key point I wanted to make earlier. The ECOSOC rights are principally I made the point I wanted to make earlier. The ECOSOC rights inure mostly from international instruments, and the rights include the right to work. And when we say the right to work, it's not the right to be employed. It's the right, when employed, to be given work to do. People sometimes make the back. I had one case when the employer said, "Well, we are paying him a salary, why should he complain?" I said, "No, you don't understand. Yes, he's in employment, but you must give him work to do, because if you don't, you have infringed that right." There is the right to wages, and the whole literature in which you find in the paper, kind of tension points wages are given rise to in Nigeria are also addressed. Even the no work, no pay rule is addressed very often, particularly you are the university. There's always this tension. So no one's parity, that's always been a tension point. Health workers want parity with doctors. State health workers want parity with federal workers. The point we have made in NIC is simple. If you want parity, make it an item of negotiation and put it in the collective agreement. So long as you don't put it there, parity is not a right you can come to court and claim. Then decent working conditions, I'll make comments on that, and it is in that relationship that we have also looked at the issue of unfair labor practices. I give examples of decisions by the court of certain kinds of practices that the court held to be unfair. And I asked the question, unfair labor practice, yes, it works more for an employee, but there's no reason why an employer cannot also say the employer also suffers from unfair practice. Then there is safety, right to safe and healthy working environment. It comes principally in terms of workplace injury, which you can claim either by virtue of the Employee Compensation Act, or you can claim through the tort of negligence. But the point must be stressed, whichever one you choose is entitled to the other. If you come to us by way of the tort of negligence, you can no longer go through the process of the Employee Compensation Act. If you go to Employee Compensation Act, you can't come to tort of negligence. And you must exhaust the processes of the Employee Compensation Act before you can come to us in an appellate way, because you will be appealing the decision of the NSITF. I showed an example of how we have treated workplace injuries under the tort of negligence in the structure of the court. And then I talked about the kind of factors we take into when making award of damages in those areas. I make a note that the right against unfair dismissal has not been fully crystallized in Nigeria, but we accept and we have implemented the concept of constructive dismissal. I know there is talk. Lawyers have called. One of the judges said we must give a reason before we can terminate. Another said no. And yes, some of our decisions have said so. Some have not. But my point is, if you look at the Court of Appeal decision by Justice Garba, who is in the Supreme Court right now, it's going to be very difficult if you don't make an issue of it. And my advice has always been, because Convention 158 has not been ratified by Nigeria, you must plead it and prove it as a question of fact. Because we have authority to apply international best practice. So you can plead Convention 158 as evidence of good practice. If the court agrees with you in terms of the case before it, then it will apply it not as a ratified convention, but as evidence of good practice, and it seems that it has been done. And I'm sure that the context in which the decisions of NIC, in which it's been held that you must give a reason, also want. We have also heard that there are certain sectors that are sensitive, and we identify the banking sector. And it's particularly pathetic because if they terminate you in the banking sector, you will never get a job in the financial world. So we are sensitive about that, and we always insist that, look, as far as the banking sector is concerned, you have to be very careful how you treat order, because you're dealing with somebody's life for life. I also talked about privacy in the workplace. And so far, not many cases have come before us. I also talked about the right to be informed and consulted, and I note that it is more pronounced now that we are in the era of COVID. Any decision an employee wants to take in relation to COVID, we advise that consultation with the workers be made. I also analyzed section 20 Labor Act, which deals with retrenchment redundancy. And I also dealt with the question of work references, which I indicated earlier is a post-employment right. And of course, while discussing the employee rights, we also address some aspects of employer interest, but I devote the whole section to the employer. So I have discussed rights like right to information consultation in the context of the right of the employer to reorganize the outfit. I have dealt with the right of an employer to transfer, which comes at 2 levels. Transfer from one company to another, or within the company, transfer from one branch to another. In all of this, I make the point that if the transfer is made to punish you for union activities, we will brand it as an unfair labor practice. We also dealt with the right of the employer to change conditions of service. It's right to post or transfer you, and the limits in which those rights can be worked. Then the right to promote. There's a part of appeal decision that says promotion is not a right, it's a privilege. We agreed with that, but the Court of Appeal did not address the question where denial of promotion is vindictive, where it is malified. What do you do? That matter came before me, and I have to rely on a good number of Indian authorities that say yes, courts are not to go in and rule against delving into domestic affairs of companies. Said yes, courts are not to go in, but that when the company acts malified or vindictively, then the court can step in. And in this particular case, what was the issue? The family of the lady took the University of Ilorin Teaching Hospital to court on grounds of medical negligence because the father died in their care. So the death certificate indicated the cause of death, which was wrong. So she collected that death certificate and gave to her brother who was in court. So for giving the brother that, and the fact that the family took the University of Ilorin to the hospital, she was suspended and told she will not be considered for promotion. So when the matter came before me, the policy question was simple. Promotion is not a right, it's a privilege, yes, no problem. But if I hold promotion is not a right but a privilege, I'm indirectly saying you can be penalized for going to court. In other words, should that rule supersede the question of going to court? In other words, should access to court be an overriding policy? I felt that it should be. And so I said, because the denial of promotion and the suspension was done vindictively, the question of it is not a right or a privilege does not even arise. Here we are dealing with you, punishing this woman because she went to court. And it is not for you as an employer to determine when an employee should go to court or not to go. There's a world of literature on the employer's right to suspend. I've discussed the circumstances in which that can happen. But I must stress the point that suspension is not an implied right. It has to be in the contract. If as an employer you don't stipulate in the contract that you have a right to suspend, you can't suspend. Please, I need to stress that point. And then of course, the yardstick for challenging suspension is whether it is necessary, reasonable, valid, and hence lawful. That's Longe versus First Bank of Nigeria. In conclusion, raise a number of issues. I would just like to read out the last paragraph. I say one last point. The reorganization exercises which transform trade unions into the present industrial unions, senior staff associations, and employers associations also transform a number of cooperative societies into trade unions. I am not too certain whether given the realities today, especially as to the nature of trade disputes that come together, this decision is not to be reconsidered. I'll give you a simple example. It's road transport workers. They were incorporated. In 1978, they were brought in and made trade unions. Now, what is trade unionism? Trade unionism is one group, the employer group, fighting their cause against the employer, is it not? In road transport, who is the employer, who is the employee? We have cases where a state government comes out, builds what we call erroneously as motor park. It's actually called garage, not motor park, but that's what we know in Nigeria. Now, they build and say, these are the category of people that can use it. A road transport union comes to us and says, X, Y, Z cannot use it because we are the only trade union. And I ask, what is trade unionism about using a garage? What is the trade unionism issue? That you are quarreling with a state government or a local government over the use of a garage. In fact, I had a private discussion with the minister of the I told you it may be necessary for you to reconsider some of these old cooperatives that we are unionized. It may be better to take them back to cooperatives. Of course, it comes with its own side effects, because as cooperatives, they no longer have the right to go on strike. But right now, what we have sometimes, we are going to find road transport workers block road. One of their trailers was accosted by police and things like that. So I make the point that we may need to reconsider those cooperatives that made trade unions. We may need to look into the possibility of taking them back to cooperatives. If the nature of disputes, especially the road transport sector, is anything to go by, disputes as to which between contending bodies has mandated own motor garages. I am of the opinion that we may need to start thinking through the necessity of returning such unions to cooperative societies instead of the trade unions they are today set. This way, they come under the direct regulation of state cooperative laws where they operate. As the National Industrial Court discharges its mandate, especially in the tussle between the employer's desire for flexibility in the workplace as against the employee's desire for security in the workplace in all its manifestations, this being the key tension point in today's world of work, the NICN has, in the main, acquitted itself. Whether, in fact, the discharge of this mandate has promoted industrial harmony is an issue left to stakeholders, government, employers, and labor. Like I tried to show, the disrespect for the rule of law and due process, which permeates all strata of our society, including the workplace, leaves much to be desired, and so will take us nowhere. My belief, however, is that we have to protect the rule of law and due process so that these concepts can also protect us. The respect of the rule of law and due process by all stakeholders will accordingly go a long way in promoting respect for workplace rights and hence industrial harmony. I thank you all for this.
was explosive. Please, another round of applause for Professor. Thank you very much. See, please. Wow. I'm sure you agree with me that that was really insightful. I was just discussing with Professor Diona. He told me that, wow, the academia lost somebody. Thank you very much, my lord. I call that lecture note a mini textbook. I need mine in my bag. Thank you. All right. We'll be moving on to take the vote of thanks, but before we do that, we'd like to recognize some of our own who have contributed so much to the development of the Faculty of Law. We're talking of the law lecturers, the former deans, they are here. We'd like to recognize Professor Emeka Chiama. Professor Richard Itubo, PhD, is here. Of course, we have Professor Nathaniel Inegbedion. We have other professors of law are here. I'm sorry if I did not mention, acknowledge you according to your hierarchy. Please just in no particular order, I will recognize Professor Bright Baswai. Professor Osaiti Aibobo, you're welcome, sir. We have here with us Professor Joe Odion. Seated to his right is Professor Matthew Olong. And of course, the man who gave us the opening prayer, Professor Eric Okuji. I thought I saw Professor Ugozi maybe somewhere. Yes, Thank you very much. My colleagues and HODs are here. Dr. Ezekiel, I can see you. Dr. Ezekiel. Okay, the chairman of the organizing committee, Dr. Nelson Odekova. Dr. Michael Atta, I'm sure I can see you. Okay, we have other colleagues of ours are here. I will not be picking on this, but I know Dr. Andrew Ejeba. You're welcome, sir. Okay, thank you. There are other colleagues who are here. I'm sure I'm not seeing you. Is anybody from black and white? So that's what to actually this right now. But thank you. You all are welcome. At this time, we're going to call. At this time, we're going to call the former Dean of Law, Professor Nathaniel Inegbedion, to give us a vote of thanks.
The NICN has discharged its mandate. Whether this is attributed to the promotion of social harmony is an issue there for the stakeholders. And so, the flourish, the guest lecturer, landed up this lecture. Let us once again give it the land. Thank you very much. So my task is very simple, and that's to give a vote of thanks. And on that note, I want to start by thanking the guest lecturer most profoundly for creating time and
for making himself available in spite of his extremely tight schedule to deliver this lecture. This lecture has been long in coming. We have had to postpone on more than one occasion. Indeed, out of frustration, I asked whether it could not be delivered virtually, and they said that delivering a lecture virtually is like talking to yourself, because you are the only person in the room. So I want to thank you very much for creating time to come all the way from Abuja and come with his entire team to deliver this lecture. Thank you. Thank you so much. And you wonder why I chose you to deliver this lecture when I met you in the chambers in Abuja. You can see the very reason why I chose you. Because we regard you, you are in a unique position because you straddle both worlds, the academic world and the world of the judiciary. And so I felt that you are in a unique position to deliver this lecture. And I'm glad that I have not approved wrong. Thank you very much for that. Let me also thank the Chief Judge of Edo State, Honorable Justice Joe Acha, for creating time in his tight schedule. And I say this advisedly because when we met him yesterday morning, he did say he had a very important engagement this morning. And he assured us that in spite of the engagement, he will juggle the schedule and make himself available. We are very grateful to you that you are able to do this implementation of the law for the faculty of law of the University of Benin. This is in spite of our shortcomings, which you expressed yesterday, but I want to say that for you. Thank you so much and for giving us for our shortcomings. Thank you for coming. I want to appreciate, though he appears not to be here again, Honorable Justice George Morin of the Court of Appeal. He has taken his seat, I guess. We want to thank